Welcome to Motivation at Hand, Ma. To know is to know how. Part 3. Case 123 CR 00257 TSC Document 139 filed November 6, 2023. In the United States District Court for the District of Columbia. United States of America vs. Donald J. Trump, Defendant. Government's omnibus opposition to defendant's motions to dismiss the indictment on statutory and constitutional grounds. A. The defendant's statutory challenges lack merit. A. The indictment alleges deceit, trickery, or dishonest means. 1. The defendant unsuccessfully attempts to recharacterize his false statements as permissible advocacy or expression of opinion to public officials. That claim mischaracterizes the allegations in the indictment, which describe the defendant's use of fraudulent, knowingly false election fraud claims. Knowing lies are neither opinions nor pure advocacy, and in any event, the defendant could not use so-called advocacy as a cover for his scheme to obstruct a governmental function through deceit. Knowing deceit aimed at defeating a lawful government function constitutes a violation of the defraud clause, notwithstanding his attempts to sanitize his conduct. The defendant also contends, ECF number 114 at 5-6, that the indictment fails to allege deceit, because his false statements would not have fooled the public officials at whom he aimed the statements. According to the defendant, he was one voice among countless millions, everyone had access to largely the same information, and the public officials he targeted were some of the most informed politicians on the planet and could come to their own conclusions. To the extent that the defendant argues that he cannot be held responsible because no one would have relied on his assertions of fraud, he is wrong. Lack of success provides no defense to a charge of conspiracy to defraud, much less any basis to dismiss the charge. The law of conspiracy identifies the agreement to engage in a criminal venture as an event of sufficient threat to social order to permit the imposition of criminal sanctions for the agreement alone, plus an overt act in pursuit of it. United States vs. Fayola, 420 U.S. 671, 694, 1975, regardless of whether the object of the conspiracy be achieved, United States vs. Thompson, 275 F Supplement 3rd 107, 111, DDC 2017. Were it otherwise, defendants captured en route to a bank robbery could not be charged with conspiracy because their crime did not succeed. Indeed, a conspiracy can be committed even if the object of the conspiracy is unattainable. See United States vs. Jimenez Recio, 537 U.S. 270, 275, 2003. The federal fraud statutes similarly punish the scheme, not its success. Pasquantino vs. United States, 544 U.S. 349, 371, 2005, and the common law requirement of justifiable reliance has no place in the federal fraud statutes. Nder vs. United States, 527 U.S. 1, 24-25, 1999. A defraud clause conspiracy, like any conspiracy, is complete regardless of whether it succeeds or is likely to succeed in achieving its objective. Here, of course, as the indictment charges and history reflects, the defendant's scheme did obstruct the government function and came dangerously close to overturning the valid results of the presidential election. In short, the indictment alleges a defraud clause conspiracy, and the court need not look further. Alternatively, if the defendant's argument is that his false claims were not material, because his voice was just one among countless millions, ECF number 114 at 5-6. And thus, he suggests, his statements did not have a natural tendency to influence and were not capable of influencing the decisions of the public officials to whom they were addressed, Nder, 527 U.S. at 16. He cannot raise it now. Materiality is an issue of fact to be addressed at trial, not on a motion to dismiss. United States vs. Godin, 515 U.S. 506, 522-23, 1995. Moreover, any such defense will fail at trial. As the sitting president, the defendant had access to far more information than others in the country. He had the benefit of the full resources of the federal government, including the top federal law enforcement officials at the Department of Justice, the Director of National Intelligence, and experts on election security, ECF number 1 at paragraph 11. All of whom were informing him that his claims of outcome determinative fraud were false. And as a result of his role and access to this information, his voice carried more weight, as indicated by his boasts about the impact of his words. Footnote 3C CNN, transcript of CNN's town hall with former President Donald Trump, May 11, 2023. In any event, this is not a matter to be resolved in a motion to dismiss. The defendant also asserts that his statements were not deceptive because he genuinely believed that the election was stolen. ECF number 114 at 7. But this, too, raises a matter for trial, not a motion to dismiss. Moreover, even if the defendant could supply admissible evidence of his own personal belief that the election was rigged or stolen, it would not license him to deploy fraud and deceit to remedy what he perceived to be a wrong, and it would not provide a defense to the charge. Even where a defendant uses deceit to obstruct government functions that he thought were unconstitutional, the Supreme Court has made clear that a claim of unconstitutionality will not be heard to excuse a voluntary, deliberate and calculated course of fraud and deceit. Dennis, 384 U.S. at 867. One who elects such a course as a means of self-help may not escape the consequences by urging that his conduct be excused because the statute which he sought to evade is unconstitutional. Same as, there are appropriate and inappropriate ways to challenge perceived illegalities. Same as, just as the president of a company may be guilty of fraud for using knowingly false statements of facts to defraud investors, even if he subjectively believes that his company will eventually succeed. See United States vs. RF, 897 F. 3rd 1, 9-10 and N9, 1st Circa 2018, United States v. Kennedy, 714 F. 3rd 951, 958, 6th Circa 2013, United States vs. Ferguson, 676 F. 3rd 260, 280, 2nd Circa 2011, United States vs. Chavez, 461 F. 3rd 1201, 1209, 10th Circa 2006. The defendant may be guilty of using deceit to obstruct the government function by which the results of the presidential election are collected, counted, and certified, even if he provides evidence that he subjectively believed that the election was rigged. Finally, the hypotheticals posed by the defendant, ECF number 114 at 7-8, do not call into question Section 371 scope or its application here. A defraud clause violation, as honed by years of judicial application, requires an agreement, identification of a specific function of the federal government, the intent to obstruct that function through deceit, and an overt act, and does not reach lobbying or other societally beneficial political behavior. See United States vs. Haldeman, 559 F. 2nd 31, 120-21 D.C. circa 1976, en banc, per curiam. Conspiracy to obstruct the lawful function of the CIA by deceptively causing it to provide financial assistance to those involved in the Watergate break-in and to falsely dissuade the FBI from investigating. United States vs. Johnson, 383 U.S. 169, 172, 184-85, 1966. In exchange for campaign contributions and legal fees. The Department of Justice by urging dismissal of pending indictments. Absent additional information about the conduct and mental state of the individuals in the defendant's hypothetical scenarios, they could not be prosecuted for violating Section 371. None of the defendant's proffered hypotheticals, for example, involve individuals acting with the demanding criminal intent that Section 371 or the other statutes with which the defendant is charged, requires. Stated otherwise, the detailed allegations in the indictment, which establish that the defendant used false statements to conspire, defraud, and obstruct, are not comparable to the defendant's vague hypotheticals. Footnote 4. The three hypotheticals the defendant conjures up in his constitutional dismissal motion CECF number 113 at 14, fail for the same reasons. To be continued. Part 4. 2. The indictment alleges deceit in connection with the fraudulent electors. Much appreciation to you for giving of your time with us at Motivation at Hand. To know is to know how. We trust you will come back soon.